if there's legitimate complaints made against the sites, aren't the minor use permits reviewed?
No.
They're not.
Tim,
that would be a code enforcement.
If it's to the point of a nuisance, we can do a permit revocation or a nuisance abatement.
But never been done or ever been done?
For a temporary event, I don't know, but we certainly have done permit revocation hearings. In fact, you had one recently related to a nightclub in a residential area.
Yeah. I struggle with this one too, because my read is, and as my experience has been with minor use permit applications, they do indeed run with the land. But I'm also looking at the kind of original intent of the ordinance. We see a 1980 rule and then a 92 or some kind of historical rulings, and they're a little bit different. And I also take the point of the comparison or the question of the need for the winery ordinance, because it does seem the case that there must have been some kind of interpretation that the current process didn't allow temporary events, or why would we have needed the winery ordinance separate and different than the existing allowance? If it was there, the winery ordinance wouldn't need to be there. So I'm a little bit confused by that still.
And we wouldn't need to be having the discussion that we're currently having over the ag events ordinance. I mean, if it has always been the case that you can go and get a minor use permit for an unlimited number of events for an unlimited number of people just on a case-by-case basis with a minor use permit, I mean, if that's the case, it's completely counterintuitive to the winery ordinance, because the winery ordinance, which the wine industry advocated for, very, very strenuously, the wine ordinance actually limits how many events and how many people you can have under a minor use permit. You can only have, I think it's 6 events per year at 80.
But maybe that's why, because if it hadn't limited it, then it would be as much as you wanted for as long as.
No, but why would the winery industry have said regulate us, limit the amount of activity we can do? That's not what they were saying.
Specter of Napa.
That is not what they were. Trust me, I was in that.
I wasn't here then. I mean, I wasn't paying attention then.
That is not what they were saying. They were saying that it's too onerous, expensive, time-consuming, cumbersome to go in and get a minor use permit for every event we want to have. We should be treated differently because we require these marketing and tasting and promotional kinds of events in order to market our ag products. And so we need an easy, predictable, affordable ordinance that lets us get these events so that we can hold them in perpetuity. And part of the reason why the county granted that was because the argument was made that because of the substantial commitments that have to be made by the wine industry to have these events, that they would not be turning away from the long-term agricultural production on their land, that it would in fact keep their land in agricultural production.
But all that sounds great, but I'm looking at what the LUO says in its little table, and it says A2, 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 which means you need a minor use permit. And I'm thinking, okay, well, if there isn't like a little star saying, and this minor use permit does not run with the land, it says that you need a minor use permit, and a minor use permit runs with the land. So it's kind of like, it seems like we're kind of stuck. I don't want to be there, but that's kind of where I ended up.
It can run with the land. It's not like we're saying, we're going to revoke it or take it away at the end of the day. It can run with the land, but it only authorized those, 12 consecutive days or 4 consecutive weekends or additional days or additional weekends, whatever was envisioned in the permit. You have the permit, it runs with the land, but it only authorized that event or those events. And that's why people were saying this is too cumbersome. We don't want to have to come in every single year to get a permit for our pumpkin. That's what they're saying now. We don't want to come in every year to get a harvest festival permit. So we need to change this ordinance so that we can do this.
But need to be, to me, I don't understand, I'm just not getting this at all. And again, this is one of those ones that I've been thinking about for a week and I understand the ATC's concerns about enforcement and everything, and I agree with them. And I understand the public's concerns about, and I understand that the applicant's concerns about paying $7,000 for something every year for something. That seems crazy too.
Yeah,
So,
I agree.
but I don't know how I can't get it out of the LUO itself. I can't get it out of the ordinances. You look at it and it says a minor use permit, a minor use. Maybe our council can help me with this. This seems to me a really straightforward legal question. If you have temporary events are required to get a minor use permit, then if a minor use permit always runs with the land, in other words, it's permanent, then why is there a question about whether you need to renew it or not renew it, or get one every year or not get one every year?
I'm Tim McNulty with the County Council's office. The minor use permits are allowed by Title 22 in the inland area. The section specifically says that you can condition minor use permits, and so I think what the practice has been is to issue minor use permits that are conditioned either pursuant to the number of events that can happen per year, or the life of the minor use permit, or any number of different ways that you can think of to regulate the things that you're concerned about causing problems if the permit's issued.
We did see as an example of that, one of the cases cited, was it Lem that had a 5-year sunset, for example, that the hearing officer put on?
Yes.
So we have seen some sort of
So what are we doing? What are we doing? Really?
I think the crux of the matter isn't that the minor use permit runs with the land, or it theoretically is in perpetuity. It's what happens with a particular minor use permit and how it's conditioned.
Well,
and minor use permits for temporary events have often limited the number of events, haven't allowed the number that was originally requested, and in the case of the LEM permit, was only given a 5-year life. And I explained earlier what the reason for that was. So the issue is what happens within that minor use permit.
Yeah, and it seems to me that what you're really saying is that when a person is applying for a minor use permit for doing temporary events, they just better make sure that they write it well.
Well,
if you want a minor use permit that will allow you to, quote, have regular events of a temporary nature, whatever that means, that's how you should write it. You shouldn't say I want to have a wedding. You should say I want to do weddings every weekend. And then
that's what happens. We get applications for a huge number, and people come in and see what they can get.
And we haven't gotten applications. We haven't gotten applications. That's the whole point.
We've got quite a few stacking up. Now that we're starting to do it this way, we're getting a lot of applications coming in. And you are absolutely right. We have come to the crux of the question, which is, what is a temporary event?
Yeah.
Mr. McNulty has said you can do a minor use permit and condition it any way you see appropriate. The question is, if you're getting a minor use permit for a temporary event, what is a temporary event? Is it a temporary event if it's something that is being authorized to happen, multiple times for years on end?
Move over into a commercial event or a
business
thing. And that is the crux of the question, and that is the policy issue that I'm not deciding. That is for the board. And I can't answer this question about MUPs